What is holistic law? It's a transition from the paradigm of law in which we operate at the moment, meaning not just the way the laws are created and the way the laws are designed, but also the way that we approach law and the way the legal profession operates. So it's moving from a paradigm which is based on adversarial practices, paradigm of retribution, in a mechanistic paradigm that's primarily anthropocentric, to a paradigm of restoration, reparation, and healing. Human rights don't exist in a vacuum. It is not possible for us to have a right to life if that upon which our life depends doesn't have a corresponding right to life. The other thing about rights is that it's the highest protection that the law gives. Our legal system doesn't really have that technology in place at the moment, but I see rights as the first step on that path to evolving better ways, more holistic ways of recognizing and valuing the relationships that we have. Holistic law really is about taking a whole systems approach to law. It comes away from the mechanistic view based on old science, Newtonian physics, that says that you can deal with things in isolation. You can take one thing out of a system without it having a knock-on effect anywhere else. And holistic law says, well, that's not actually how the world operates. That there is a universal law that governs the way the whole of life operates, and when our laws and our approach to law is aligned with this universal law, that we create a cycle of happiness, of peace, of prosperity. And when we're misaligned with these laws, we actually end up producing the opposite. We have environmental degradation, we have vast disparity between the haves and the have-nots, social inequity, and all these kinds of things that take us away from peace. Holistic law is about approaching law in a way that can bring us closer to living in harmony and peace with nature and with each other. Puts a focus on the relationships. If we think of law as that which governs relationships, it then naturally follows that law should take into account all of the relationships that we have. And primarily, at the moment, law only takes into account certain relationships between what the law defines as right holders. If you are a rights holder, at the moment there are only two categories: human beings and entities that are created by human beings, like corporations. So our modern law only recognizes relationships between human beings and corporations and other entities like that, like ships. However, it doesn't recognize that we're actually in relationship with the natural world, let alone that this is our most fundamental relationship. So in law, there is no relationship between the human being and that which our life is dependent on. Rights of nature is very much about consciousness, and it's also very much about economics. There is one key concept that underlies our economic paradigm, and that's the utility value of nature. This utility value means that nature is just there to satisfy the wants and the desires and the needs of human beings, and that it has no needs of its own, that it's dead, that it's inert. And accordingly, law facilitates that paradigm, the paradigm which rests upon the commercial exploitation of nature. Because we don't have a relationship in law with nature, we have no obligation to nature. The rights of nature really shifts that whole paradigm, because we move out of utility value of nature, the usefulness of nature to human beings, to intrinsic value, valuing nature as we would value a human being. Fundamentally, we are nature. When we do that, and we recognize nature as a rights holder, we're using a powerful legal tool that has been used throughout the centuries to address inequality of power and social injustice. So, for example, it was not very long ago that women and children were also considered to be property. However, in the civil rights movement, women and children became recognized as rights holders. The same with slaves. It would be inconceivable now to think of certain people being mere property. Yet, this was there in our legal system, entrenched in law. The slavery trade was actually very similar to the fossil fuel trade. It was something like a $75 billion industry in its day. However, the rights movement put an end to all of that. And so if we look at the way, the exploitation of nature nowadays, there are a lot of parallels with the slave trade. Looking at the precedent of how rights has had a knock-on effect for shifting and evolving the consciousness of the people, really applying that same tool and that mechanism to nature, I see as a real way for not just shifting the paradigm, but also for shifting the consciousness, people recognizing and expanding our sense of community to the community of all life, the community of everything that exists. Under law, the prima facie situation, the basic premise is that none of nature is protected. So environmental law comes in to carve out protections for those areas of nature that we think is worthy of protection. So we end up with this piecemeal protection system. So laws like the Habitats Directive, the UK Countryside Act, they revolve around what we perceive to be endangered species. And these laws operate through a system of annexes, and in these annexes are detailed the species and the habitats for these species that need protection. However, it takes years to update an annex. You need extensive scientific research. And currently, we're losing something like 1,000 to 10,000 times the backdrop rate of species extinction. So that means literally 10 to 12 species are going extinct every day. And in an fluidly interconnected world, as we know the world is, when we look at all the scientific disciplines that we have now, look at systems theory, look at quantum physics, we see that we live in a radically interconnected world. When you take out one species, it does have a knock-on effect on everything else. So these laws are not really designed to operate in a way that functions in harmony with how ecosystems actually operate. By the time it takes to get all the documentation in place to update an annex, we've already lost a whole load of species. So really that system is not fit for the challenges that we're facing at the moment. As in the law, the way utility value translates is that nature is property. So the other knock-on effect of nature being property is that all environmental issues become planning issues. And they're looked at exclusively in modern law by the planning courts. So for communities to protect nature, it's not possible for them to just stand up and say that we need to protect nature because our lives depend on it, because we live in an interdependent world. What we have to do is find that there has been some technical fault with the planning procedure, that the correct planning procedure wasn't followed. This makes it incredibly difficult to actually stand up and protect nature, because we're trying to protect nature using a legal system that's actually designed to facilitate the exploitation of nature. Biodiversity offsetting says that it's designed to speed up the planning process by saying that we don't need to do environmental assessments. We can destroy one ecosystem here and replace it with another ecosystem somewhere else. Now, that's in that mechanistic paradigm that you can separate something off and it has no knock-on effect on everything else. But as we know, in a radically interconnected world, you take out one ecosystem, replacing it with another somewhere else is just not really going to do the trick. And coupled with policies to enable fracking, we have a huge escalation of possible environmental degradation that could really have irreversible effects. Rights of nature is actually the next emerging paradigm in environmental law. It's happening. It's happening today and it's happening around the world. For example, at the national level, we have Ecuador. Ecuador was the first country to introduce the rights of nature in its constitution. And the way the constitution is drafted is really quite enlightened. It says in the constitution itself the words that we recognize that the earth is Pachamama, a living deity. A living deity who has the right to exist, persist, and renew her vital cycles unimpeded by the activities of mankind. We have Bolivia. Bolivia also has very similar laws. Instead of putting it in the constitution, Bolivia have put it in law, and they actually have an ombudsman for Mother Earth, operating upon similar lines and with the full rights of nature. Also, there are movements. Mexico City has recently brought in the rights of nature, and there's a campaign to bring it in at national level. Colombia has also got a campaign going to bring in rights of nature at national level. In the United States, we have a ground-up movement. So the rights of nature is recognized in around over 36 municipalities, over 36 municipalities, including some large cities like Santa Monica and Pittsburgh. And these places not only recognize the rights of nature, they also grant rights to communities to defend the rights of nature, and they also subordinate corporate interests to the interests of ecosystems and natural people insofar as the corporation's actions are against the common good. And the common good being based upon what is beneficial to the whole, including the other species in the ecosystem. We have various court decisions around the world. So New Zealand recently had a court decision where the Whanganui River was recognized as a living being with legal personhood. In Costa Rica, there was a court decision saying that the second largest reef in the world cannot be commercially exploited because it is a living being. There's also been rights of nature cases that have been through the courts in Ecuador, where the rights of nature of the Vilcabamba River, that it could not be polluted, and an injunction was taken against the government to stop the pollution, invoking the rights of nature. So it's really a very powerful tool. In India, there's a campaign to recognize the Ganges River as a living being, following the New Zealand example. And in Europe, we're bringing a European Citizens Initiative to recognize the rights of nature via a directive at EU level. I believe in a whole systems approach, a systemic approach, because by dealing with one thing in isolation of looking at the knock-on effects elsewhere, we're back in that mechanistic, the Newtonian physics paradigm, which we know is well outdated. And so, the way forward is to look at things in the round, and rights of nature is really a game changer. It's really a paradigm shifter. It gets to the heart of the commercial exploitation economics that's leading to all of these undesirable effects that everybody is so aware of these days. And so I really wanted to put that on the table and to bring it into the mix amongst all of these other great thinkers, to see how we can evolve something that's a much more robust structure for not just us, but our future generations and the future generations of all species going forward.